Constitutional Law 2, Parliamentary Privileges or Privileges and Immunities of Parliament is the topic for discussion today. Article 105, 121 and 122 in respect of Parliament. Articles 194, 211 and 212 in respect of state legislature. Various privileges and immunities are provided under the Indian Constitution. In this lecture, we will have to discuss about meaning, definition, significance, and background of these parliamentary privileges and various instances under which these parliamentary privileges and immunities are extended. So these privileges are with regard to freedom of speech and expression within the four walls of the parliament and state legislatures, freedom as to publication of parliamentary proceedings and debates, and freedom to in respect of arrest and detention of members for the acts done, and freedom as to regulate internal proceedings and prohibit strangers. Fifth one, privilege to prohibit publication of reports. Sixth point is privilege as to privacy of debates and secret meetings. Seventh circumstance is privilege to hold enquiries and summon witnesses. And last and most important is privilege to punish members and members or outsiders for breach of privilege and contempt of the house. These are the eight circumstances under which the parliamentary privileges are provided. Now, before going to know discuss this topic, we should know what do you mean by privilege, what do you mean by immunity, what do you mean by parliament, what do you mean by state legislature. As all of you are expected to know what is parliament, what is state legislature. Parliament is Lok Sabha, Rajya Sabha. Lok Sabha headed by Speaker, Rajya Sabha headed by Chairman, and then President of India. Lok Sabha, Rajya Sabha, and President of India collectively known as Parliament. The Legislative Assembly, Legislative Council, headed by Speaker and Chairman respectively, and then by Governor, collectively known as state legislatures, is what you are expected to know. And these houses, these houses are law-making houses. For Lok Sabha, Rajya Sabha, Speaker, Chairman, and President constitute Parliament at a central level. Legislative Assembly, Legislative Council, headed by Speaker and Chairman respectively, and finally under Governor, collectively constitute state legislatures. So these the fundamental principle of any democratic country is free, fair debates in houses, that is both parliament and center and state legislatures at state level. The members are designed to fight for the cause of the people. They have to speak. They should be allowed to speak very freely and frankly and question anything and everything within the four walls of the houses. Whatever they speak within the four walls of the house during the debate, question hours, whatsoever is has to be protected. Unless some constitutional protection is given without the fear of civil and criminal liability, the members will not be able to justify their responsibility they are shouldered with. So they are designed to represent the people before the house. They must act for the welfare of the people. When they are shouldered with such responsibility, they have to speak fearlessly without any hesitation, so that then only they'll be able to do justice for their people. For this purpose, in every democratic country, the fundamental principle is free, fair, and free and fair discussion is very important. This is fundamental principle. That is why not only in UK Parliament but also in India, certain privileges and immunities are provided to these members of the Parliament and state legislatures. Now, coming to the what do you mean by privilege? What do you mean by immunity? We have to know. So, you all know what is Parliament, what is a state legislature. Anyway, I told you. Now, what is the meaning of privilege? What is the meaning of immunity? This meaning of privilege and immunity, I will tell you in general and in particular with reference to parliament and state legislatures. Here, privilege means some special right or favor conferred, given, provided by virtue of sex, race, religion, age, status, vulnerability, whatsoever, insanity or physically handicapedness, whatsoever. There are certain categories of people uh, who are placed in a special position to enjoy certain additional benefits or extra treatment. So that special right is called such special right, special benefit, special treatment given to such people is called privilege. Those persons are called privileged people. So this privilege, in general, I tell you now, the privilege may be given, the special right or favor may be given on the basis of sex. You know, the women are provided with so many welfare legislation. They are provided separate queue lines in railway station. They are provided separate reserved seats in state service transport buses. Likewise, the women get some committees and meetings, elections, the women reservations are provided. So that is what is called some privilege, right conferred on the basis of sex. Similarly, age. Senior citizens are provided so many privileges and immunities. Immunities, you know. Religion. So, Article 29 and 30 of the Indian Constitution provide certain special privileges, special provisions to minorities, communities to conserve the language of their own, to administer the educational institutions of their own, like that. And community, SC, ST, OBC candidates are provided reservations in educational institutions and employment also, what you know. Then position, position. So there are certain people, they are designed to fight for the cause of group of people. For example, the trade union leaders. The trade union leader, he must speak very fearlessly, daringly, dashingly to the higher authorities, because he is representing the working class, thousands of workers. For example, there is a state transport service, bus service, agitation is there for payment of hike in salaries or other benefits or pay revisions. So the transport people, they start to strike, and all the vehicles in the state may be stopped. Or similarly, postal strike may take place. It will result in lot of inconvenience to the people. In such case, the trade union representative or workers representative or SAP representative may hold very small post. He will have discussion with the transport minister or post and telegraphs minister, maybe state level minister or central level minister. Very ordinary employee is privileged to have a hand face to face discussion. Even very top level officials won't be able to get the interview of chief minister or prime minister, whereas a bus driver or conductor who is a trade union leader in respect of state transport services will have to discuss with the chief minister and transport minister. So in case in during the course of discussion, the trade union leaders are to speak, discuss fearlessly, daringly, dashingly, keeping in mind the welfare of their working class. Speak clearly without any fear of civil or criminal liability. In during the discussion, they are if they speak, they are totally immune or exempted from this liability. So that is the by virtue of status or position they are given. Next one is these are the some privilege is some special right or favor provided or conferred by virtue of sex, race, religion, position, etc. Now, the second word is immunity. Immunity means exemption from liability. Immunity means exemption from the liability. In the eyes of law, all are equal. Right from the porter to the Prime Minister of India are subject to law. The rule of law is law, it is rule for all, right from the lowest in cadre and to topmost to the cadre. However, certain all are equally liable for the wrong done, whether it is a civil wrong or criminal offense. But however, there are certain special classes of people, they are exempted from civil liability and criminal liability under certain circumstances. For example, immunity. State is immune from liability on the ground of sovereign. That is, I explained in detail in state liability or sovereign immunity in law of torts and administrative law also. In this constitutional law too also, the state liability, that is tortious liability and contractual liability, is one chapter in constitutional law too. This topic I have already covered in administrative law. Both are almost same, identical. The students are advised to refer my lecture, state liability, that is tortious liability and contractual liability from administrative law. And now here, state sovereign immunity. State is not liable for certain acts committed by its servants, committed by its servant on the ground that state is sovereign. That is, king can do no wrong, but subsequent developments are there. I had already told. Next, President of India, governors, diplomatic envoys, that is, ambassadors, the foreign ambassadors, they are not answerable in courts. They are exempted from civil and criminal liability. Then age. By virtue of age, child be up to 7 year old is totally exempted from criminal liability. Child between the age group of 8 years and 12 years is punished subject to proof of mens rea, and juveniles up to 18 years of age, boy, girl 21 years, which may the age may change from time to time as per present manual of the respective state. They are given some special privilege and immunity with reference to treatment, and a minor cannot be sentenced to death. That provision also is in discussion after this recent rape case. And finally, community and SC ST candidates are exempted from college fee, school fee, employment application fee or reduced fee like this. So similarly, pauper mean and indigent person is totally exempted from court fee and fee from free to prefer appeal. All these are immunities. So privilege means some special right conferred by virtue of sex, race, religion, or position, in particular social status. And another thing is immunity means exemption from the liability. Simply, privilege means some special right or favor. Immunity means exemption from liability. It may be civil and criminal. So this is this so far as in every democratic country, it is very essential to confer, provide certain privileges and immunities to the members of legislatures, central and state legislature, but for which they will not be able to discharge their duties to the satisfaction of all the concerned. Otherwise, if these certain privileges and immunities are not provided to the members of the legislative houses, they won't be able to speak freely and frankly in the interests of the people in general. That is why this privilege is some special right or favor conferred to the members of the houses. Immunity refers to exemption from civil liability and criminal liability under certain circumstances. So that is why definition. Sir T.F. May, in his book Parliamentary Practice, Chapter 2, page 42, 16th edition, defined privilege that some of the particular rights enjoyed by each house collectively as a constant part of parliament and members of each house individually, without which they could not discharge their functions and which exceed those possessed by other bodies or individuals. According to this definition, Sir T.F. May, a distinguished jurist, defined in his book Parliamentary Practice that the privileges are particular, some special rights conferred on the houses, parliament or state legislatures, and also the members, its members, members of parliament and state legislatures to discharge their duties effectively. Otherwise, they won't be able to discharge their duties effectively. So they are enjoying such. They are enjoying such privileges and rights which all other members, ordinary members in the society cannot possess such privilege. This is the definition. So according to this definition, these privileges and immunities are categorized under two heads: collective privileges and immunities on houses. The immunities and privileges conferred on the houses collectively, and Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, and the committees. Sometimes the Lok Sabha or Rajya Sabha may appoint some committee on a particular issue, and the committee comprises of the members of the house or some outsiders, some distinguished jurist or something, or subject expert also may be there. In state legislatures also, certain issues, legislative assembly or legislative council, the house may appoint some committee to decide about something. So if any law is to be passed, if any challenges are there on that particular bill any bill is proposed to pass a particular act or enactment, there are any challenges or questions on that, to arrive at the conclusion, some committees may be appointed. For checks and balances between executive, legislature, and judiciary, certain committees may be constituted. The committees may be within the members of the committees may be members of the parliament or state legislature, or sometimes outside members. So not only the members of parliament houses and state legislative houses, but also the members, if outsiders, if any subject experts or technically well-known personalities, learned person, they also are entitled to enjoy the privileges and immunities. So, according to the definition of Sir T.F. May, these parliamentary privileges are collectively available to the houses of the parliament and houses of the state legislature. These privileges and immunities are provided to the committees collectively, and these privileges or immunities are provided to the individual members, MLAs at state level, MLAs and MLCs at state level, and MPs at central level. So that means the house as a whole collectively enjoy privileges, and the individual members also will enjoy privileges. Article 194, Article 105, 105, 121 and 122 of Indian Constitution provide certain privileges and immunities on Parliament at central level. Article 194 and 211 212 confer certain privileges and immunities on the houses and members of the state legislatures. This is the topic. Now, this what is the origin of these these privileges and immunities are conferred or provided to the houses and members in most of the democratic countries in discharge their functions to discharge their functions effectively. Not only India but also America through a Bill of Rights 1689 provide these privileges and immunities to the Parliament. So UK Parliament. Now coming to the next topic, background. So what is when this importance of parliamentary privileges was recognized? The history of the concept of parliamentary privileges can be traced back to 1833 with the passing of the Charter Act of 1833, wherein fourth member was added to the Governor General and Council. Thereafter, the privileges are continued. In course of time, the most important enactment, Government of India Act 1935, Section 28 of the Government of India Act 1935 provided for the privileges and immunities of members of the parliament and state legislature so as to enable them to free speak frankly and discuss daringly to for the cause of the public as a whole. So this is the Charter Act of 1833 and section 28 of the Government of India Act 1935 paved way for these parliamentary privileges and immunities. Our Indian Constitution was drafted taking Government of India Act 1935 as basis, and the constitutions of other countries, Australian Constitution, Swiss Constitution, and other written Constitution, French Constitution, Indian Constitution was drafted under the able favorable auspices of the then Baba Ambedkar, drafting committee chairman. So these are the Government of India Act and various aspects were taken into consideration for drafting this Indian Constitution. So in this, these privileges and immunities are provided to state parliament under Article 105, under Article 105, 121 and 122. For state legislature 194, 211, 212. These things I have to discuss in course of time. Now, there are various instances wherein the parliamentary privileges and immunities are conferred. First point is privilege as to freedom of speech and expression. Privilege as to freedom of speech and expression. Article 105, 121, 105, 121, 122, and 194, 211, 212 are the relevant provisions. So, whatever in parliament houses, that is Lok Sabha and Rajya Sabha, in state legislatures, that is Legislative Council and Legislative Assembly, the members during sessions, they are absolutely free to speak anything, express anything, accuse anything, question anything. Whatever is spoken, whatever is discussed, whatever is professed, even out of great jar in will, within the four walls of the parliament is absolutely privileged. That member, suppose an MLA in assembly speaks, makes a defamatory statement about central minister or any other politician, any other reputed person outside the house. Whatever is spoken within the four walls during the sessions is absolutely privileged. They do not have any civil liability or criminal liability. So that is why when they are absolutely immune, exempted from civil and criminal liability, the members can speak daringly, dashingly, anything without any fear of civil and civil suit or criminal action because they are provided. However, this privilege is given to members of parliament, that is Lok Sabha and Rajya Sabha, under Article 105 of Indian Constitution. The similar privilege is conferred on members of the state legislatures, that is Legislative Assembly and Legislative Council, under Article 194 of the Indian Constitution. However, this privilege is subject to certain exceptions. Subject to certain exceptions. So, according to Article 100, according to Article 111, 111 of the Indian Constitution, I will tell you this section. According to Article 121, according to Article 121 of the Indian Constitution, the members of the parliament in Lok Sabha or Rajya Sabha can make any statement or profess anything, even about any politician or great personalities in the society. They do not have any liability of liability, the civil liability or criminal liability. According to Article 121 of Indian Constitution, their voice is subject to one restriction. That is, they must not speak wrong about the conduct of High Court judges or Supreme Court judges. What's a great position, great privilege is conferred on judges of High Court and Supreme Court, which is not provided to even topmost politicians and great personalities in the society. That is what, dear friend, you have to bear in mind. What a great privilege and position conferred on judges of High Court and Supreme Court, so that you have to do your minimum justice to be regular and punctual in your legal studies. So then only you will be able to do justice to the privilege, great status conferred on judiciary. Now, similarly, in state legislatures, according to 211, Article 211 of the Indian Constitution, in state legislature, the conduct or business of any High Court judge or Supreme Court should not be discussed. Even Chief Minister or Prime Minister or Central Government, whatever it may be discussed, but judges should not be discussed. This is the position. Except impeachment move. The Parliament, there is no question of in state when any High Court judge or Supreme Court judge is to be removed by service, an impeachment move is to be proposed between the Parliament, both houses. So then two-third members of the Parliament in Lok Sabha and Rajya Sabha must meet and vote in favor of that impeachment. Then only any High Court judge or Supreme Court judge will be impeached from the position. That is, he will be removed from the service. But so far, 6-7 times the impeachment move was made. 2 times Supreme Court, one Supreme Court judge and Chief Justice, and remaining High Court judges, Chief Justice, 6-7. So the impeachment moves were made, but all were defeated. One judge from West Bengal resigned before the impeachment move. So these are the things. Similarly, Article 122 tells that the House also will have privilege. The Parliament also will have privilege to regulate the proceedings and debates, to take any disciplinary action, and to render any particular member disqualified, and such things. In such things, the judiciary should not encroach upon the power of the houses also. The houses also will have some autonomy, and that the judiciary should not encroach upon the powers of these houses. So that is 122 for this parliament, and 212 in respect of state legislatures. This is so. Now one more point to be borne in mind, that here the privilege and immunities conferred on members of parliament and state legislature are quite different from for this freedom of speech and expression provided to members of parliament and state legislature is different from freedom of speech. There is a fundamental right provided to the citizen of the country under Article 19(1)(a), which is subject to reasonable restrictions under Article 92. This freedom of speech and expression and reasonable restrictions I explained in detail in Constitutional Law 1, Fundamental Rights, Freedom of Speech and Expression. So, in this connection, we have to discuss about most important case, that is P.V. Narasimha Rao versus State. The Supreme Court 5-judge bench by majority of 3:1 said that the scope of protection of immunity available to the members of parliament is quite wide. The scope of the protection of immunity available to members of the parliament is quite wide and is not confined to judicial proceeding but is available to them against all civil and criminal proceedings for anything said or any vote given by them in the House of Parliament. So the members of the Parliament can speak anything by the time of for voting purpose or debates purpose, discussion purpose. They can do anything and everything. The scope of protection to members of Parliament is very wide. The courts also cannot will not the members do not lose their protection of courts also as per article as per article 121. So this is the in this case what happened was in when P.V. Narasimha Rao was in prime minister, there his government was minority government. There was no confidence motion was initiated in order to win the no confidence move. Certain members of the parliament MPs were bribed, and this matter was challenged. And when this question was challenged, the courts said that the Supreme Court by majority 3:1 said that these things, the scope of protection available to members of the parliament is very wide. Even judiciary also cannot dilute the protection provided to the members of the parliament, even though the members who voted were bribed. So the impeachment move cannot be challenged. But even this protection is not available to the members, who have received money but did not vote, is what this Supreme Court said. This is with reference to freedom of speech and expression provided to the members of the parliament and state legislatures. Second point for discussion is privilege as to freedom of publication. So what do you mean by privilege as to freedom of publication? Here, the parliamentary proceedings and parliamentary debates can be published. In the recent past, we are able to see the live telecast of parliamentary proceedings. In recently, we are privileged to witness the live telecast of Supreme Court trial also. So here, with the permission of appropriate authority, the parliamentary proceedings or debates in the parliament or similarly in state legislature can be published by any editor, any journalist or any outsider with the prior permission and approval of the respective authority. So any while publication in getting the parliamentary proceedings, the proceedings of parliament or state legislature got published, it may give room for any defamation, result in any civil or criminal liability pertaining to other gentlemen. The person who made that publication, who got it published with prior permission of the appropriate authority, is exempted from any civil and criminal liability. This exemption for civil and criminal liability to the publisher is provided by Article 361A, which was inserted under 44th Constitution 44 Amendment. So, any individual, editor, publisher, or outsider with the prior approval or permission of the Houses can publish the parliamentary proceedings or state legislature proceeding. This privilege is given under under Article 361 A. So this is with reference to this. So in the last point, anything can be spoken. I forgot one point, dear friend. That is. The members of parliament enjoy privilege for anything spoken in parliament. The word anything means everything. This was related everything. If anything can be spoken means the members can speak everything, but everything in the sense they get protection only within four walls of the parliament, not outside. The outside they are like any in T.K. Jain versus State 1970 Supreme Court, the Supreme Court said that the word anything can be spoken by members of parliament means everything. Everything means within the four walls. And next, another one is Satish Chandra versus Harisadan Mukherjee. The Supreme Court said in this particular case that so when outside the parliament, whatever is spoken by members of the parliament or state legislatures, they are like any other ordinary member. They are liable for punishment under section 490 500 of India 500 of Indian Penal Code for defamation or any libelous statement is what decided in this particular Satish Chandra's case. And these 2 points are over. Third point, freedom from arrest and detention. Arrest and detention. Here, the members of parliament and state legislature are protected from civil liability and criminal liability within the four walls for whatever spoken. But outside the house, they are like any ordinary members. They are like any ordinary member. They are subject to civil liability and criminal liability. But civil liability, there is some special privilege. For these members, for having done any civil wrong, they will have some liability. However, according to section 135 of Civil Procedure Code, if any civil action is to be taken against any member of the parliament or state legislature before 40 days of the commencement of session, 40 days before the session and 40 days after the session, and during the sessions, the person civil liability cannot be brought to the court, summons cannot be issued, brought to the court, or if any in civil liability, civil prison issues also may be there. If the judgment debtor could not meet the decree, the court may order in execution proceedings to arrest that person and put him in civil prison. In that situation, no action can be taken, civil action can be taken against member of parliament or state legislature 40 days before commencement of session, during sessions, and 40 days after the session. So there is no such immunity in respect of criminal liability. So any action is to be taken. If any member is to be arrested, the permission from the head of the house should be taken. If it is Lok Sabha Speaker's permission, Rajya Sabha Chairman's permission, Legislative Assembly Speaker's permission, Legislative Council Chairman's permission has to be taken. So that there are in the event of if the member is charged with some special legislation for criminal activity, that is Maintenance of Internal Security Act, National Security Act, Prevention of Detention Act, Prevention of Detention Act, ESMA, Essential Services Maintenance Act, like that. For those things, immediately the person, the member of any house can be arrested with the prior approval of the chairman or speaker concerned. So here, ESMA, once Mr. Jayalalitha ji employed this ESMA, and all government employees were removed from service. That is the essential services mean ESMA can be ESMA can be exercised by the government for essential services like water supply, electricity supply, and transport, bus transport, etc. So this is the position. Now, arrest from detention, arrest from detention. So here is this thing. See, K. Anandan was Chief Secretary, Madras. In this case, when a charge against Preventive Detention Act is there against a member, that person, should be arrested. There is no any special exemption from Essential Services Acts like ESMA or Preventive Detention Act. So, if any person is to be the member of the house is to be arrested by under Preventive Detention Act, he will not get any immunity. So here one more important thing in this case is in state the Supreme Court in July 2021 rejected the plea of Kerala government to withdraw the criminal charges against the MLAs. So here the saying that the Supreme Court in July 2021 said rejected the plea of Kerala government to withdraw criminal cases of MLAs, saying that the privileges and immunities are not the gateways to claim exception from general law of the land, particularly in criminal law, which governs the action of every citizen. Criminal law governs the action of every citizen. So the people, the courts, the Supreme Court made it very clear. The privileges and immunities, the privileges and immunities are not the gateways of the members to claim exemption from criminal liability from members or the houses. No. These privileges and immunities are not gateways to claim exemption from criminal liability, because all persons are equal in the eyes of law, and particularly all people in the country are subject to laws of the land, in particular the criminal law which regulates the human conduct, is what the Supreme Court said. When the Kerala government requested the Supreme Court to withdraw the cases of its members from criminal cases of the member, the Supreme Court said, no, you cannot claim. These privileges and immunities are not gateways to claim exemption from civil and criminal liability is what Supreme Court said. And recently, on 15th, Enadu 7 o'clock daily, 7 o'clock news, Enadu 7 o'clock news, Telugu news, it was said that most of the cases are pending. There are innumerable number of cases pending beyond 5 years. The innumerable number of criminal cases are pending against politicians in the country in various high courts and Supreme Court. The duration is above 5 years, and some public interest litigation petition is filed, and the Supreme Court gave direction to take necessary steps for disposal of these criminal cases. There are so many cases attracting capital offences also. For that purpose, the Supreme Court gave direction to appointment of new staff and special public prosecutors also to dispose of the case. This is what given, because there is inordinate delay in disposal of the cases, particularly the criminal cases of politicians, is what for what the public interest litigation was filed by in Supreme Court. Now coming to this is thing, and freedom of regarding arrest, this topic is over. Next one is very simple. Privilege has to regulate internal proceeding. So The houses have exclusive rights to the houses have exclusive right to take any necessary action for to regulate the internal proceeding. Article 100 and Article 112 central houses, Article 212 state houses. The houses are enjoying the autonomy. They have some privileges and immunities. In such cases, the courts also should not interfere, as in the case of that P.V. Narasimha case. But in this particular case, this is what this Barababu's case Manipur speaker claimed, but the Supreme Court did not agree for that, and that topic we will have to discuss later. So that the privilege has to regulate internal proceedings. So here, Parliament, Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, they can take any action relating to regulate the internal proceedings. Sometimes the members may create a lot of nuisance in the house. Certain members may be expelled, suspended for a few days from the assembly. Some of the housemaid declare particular member as disqualified. Certain things the house may take place. That is what is called the houses are privileged to take certain actions in order to regulate the internal proceedings. That is the fourth point. Fifth point, privilege to prohibit publication of reports and debate. So anybody can publish the reports and parliamentary proceedings or state legislature proceedings and debate with the permission he publishes. The protection under Article 361A is there. If they are published without the prior approval or permission of the appropriate authority, the person will be subject to civil and criminal liability. Next, sixth point, privilege as to privacy of debates and secret meeting. There are circumstances in which the parliament houses and state legislative houses may conduct some secret meetings and private debates. Those are not, they are strictly prohibited. No stranger is allowed. They must not be published. So, for public purpose or some special purposes, the central legislatures or state legislatures, Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, may conduct some special and secret meetings and debate. They must be strictly kept in secret, and nobody, they should not be disclosed. If anybody instrumental for disclosure is to be punished as per law. Next, last point, privilege has to hold enquiries and summons the witnesses. Here, in central houses, Lok Sabha, Rajya Sabha, or state legislatures, assembly or council, there may be certain situations to appoint certain committees to investigate, asking the committees to investigate into certain aspects. For the purpose of inquiry and investigation, the committees may require the evidence of certain persons, and the witnesses from outside may be called for. So, in order to arrive at the conclusion of the particular inquiries and investigations, if any outsiders are called for to appear before the house and to give evidence, give evidence, those witnesses also enjoy the parliamentary privilege, whether it is in respect of legislative house like assembly or council or Lok Sabha or Rajya Sabha. If in the course of investigation and inquiry, if any outside people are called for as witnesses to give evidence, they also get or they are also entitled to a privilege and immunity from civil and criminal liability. These are the 7 points over. Next, most important point is last point, privilege to punish members or outsider for breach of privilege or contempt of court. So, the house has the power to punish not only the members of the house for breach of privilege or contempt of the house. Breach of privilege means violation of privilege conferred on members of the parliament or state legislature. if anybody has done an act violating the privileged position of any member of the parliament or state legislature, that person who has committed an act violating the privilege of member of state legislature and parliament, that person may be brought to the house and will be punished. So the breach of privilege. So contempt of the house, just like contempt of the court, contempt of the court, contempt of house also is there. Suppose I told you at the contempt of court, suppose the senior, suppose the judge has given some judgment, the senior judge is a young man, but there are seniors advocates crossing 60, 70 years, they are more knowledgeable than judge, practically speaking. However, if the judgment of the judge is not satisfactory, the advocate has to prefer appeal before the higher court, but he should not make any adverse comment on the against the judge. So that is, if he does so, it constitutes contempt of court and imposes civil and criminal liability. Civil and criminal liability. Similarly, one should not speak in cell phone, and one must everybody must switch off the cell phone in court halls. Suppose accidentally he forgot, cell phone rings, even for ringing of the cell phone also it may amount to contempt of court. The person may be fined or even sentenced to imprisonment for a few days. So here this aspect I will explain in detail. So this is, so here the houses, Lok Sabha, Rajya Sabha or Legislative Assembly or Legislative Council, they are empowered to punish not only members of the house but also outsiders for breach of privilege or contempt of the house. There are three leading cases on this. Breach of privilege means violation of any privilege enjoyed by members of the house. Contempt of court means if anybody acts in violation of in violation of the house, the house may call for that person to appear before, and the courts may order to arrest and place before the house. So this is with reference to privilege to punish, privilege of the house as to punish members or outsider for breach of privilege and contempt of court. There are three leading cases, including legal history. One case is there. Four cases I have to discuss. First case is Keso Singh versus Speaker. This is 1965 Allahabad High Court case and Lucknow bench. What happened in this case was one Mr. Keso Singh, he was a worker in a Socialist Party. He, along with three, four others, published pamphlet and distributed the pamphlet in Lucknow city and assembly compound. Assembly compound. These pamphlets contain some defamatory matter about one MLA, some Narsimha Roy or somebody, one MLA, he indulged in corruption and all. So this pamphlet reached speaker's table, and the assembly, Uttar UP assembly Lucknow bench took decision to arrest and place this Keso Singh, a worker, before the house. And along with him, some three others were arrested and placed before. But this Keso Singh could not could not attend because this Keso Singh worker who issued pamphlets along with others, he was the resident of Gorakhpur. He could not reach, and then he was arrested later and kept in Lucknow district jail. He was sentenced to 7 years imprisonment. Already 6 years imprisonment was already served. In meanwhile, one advocate of Lucknow bench High Court moved the petition for habeas corpus, stating that the conflict between legislature and judiciary, it is the most burning, most important issue. If I, then what happened is the petition for habeas corpus presented by application for writ of habeas corpus filed by advocate was entertained by the Lucknow bench High Court. and this act, the act of the House was considered illegal because no reasonable opportunity was given, and then this case sourcing was required to be released. But it got angry to the House, and the House took decision to arrest not only case sourcing but also advocate who filed petition, and also the two judges who set aside the action of the House. And then the judges they filed a petition in High Court under Article 226, challenging the act of House illegal, and the act of High Court is as per law. That is this. So this matter went to Supreme Court. The Supreme Court decided in favor of the against the House, stating that here in England Parliament is supreme, but in India Parliament is not supreme. Parliament is not supreme. So here, even though in UK the Parliament is the ultimate topmost authority, it can do anything and everything except woman a man and man a woman, as enunciated by Professor Dicey, a distinguished jurist. But in India, the Parliament, Indian Parliament is not supreme, is subject to certain restrictions and judicial control also. At this stage, the matter was pending. Even then, this in this juncture, the President of India, under Article 143 of Indian Constitution, wherein he referred this matter to the Supreme Court for advisory opinion. Then Supreme Court said, in India, a parliament is not supreme like UK. The action of High Court is valid. That judgment is given. So here in Inadu case also, the Inadu privilege move case also is there. In 1984, at that time in Andhra Pradesh state, there were legislative assembly and legislative council, and the government was ruled by Congress, headed by Chenna Reddy government. And at the time there was some quarrel, elders commotion. We witness in most of the assemblies there is a quarrel between ruling party members and opposition party members, and there is a lot of commotion. The incidents of commotion was very frequent when at the time of separation of Telangana from Andhra Pradesh, and similarly Mrs. Jayalalitha assembly, when she was wherein she was insulted like anything. So these are the such things like that. In a legislative council, some quarrel took place between the members ruling party and opposition party, and that then chief editor Eenadu Daily and News Daily. Eenadu Telugu regional language paper, News Time is English paper. Both were published by the managing director and chief editor of Ushodaya Publications, Eenadu Daily, News Daily, Sri Ramoji Rauji, for having published one advocate and businessman in Vijayawada, Andhra Pradesh, now present capital of this nearby Amravati, moved this matter as a conflict between judiciary is a contempt of the House, and thereby immediately the Legislative Council responded for that and ordered the concerned police to place Ramoji Rauji before the House. Meanwhile, Ramoji Rauji flew for Delhi and obtained anticipatory bail. So now the then police commissioner Prabhakar Rauji, was it a typical situation? In case if he arrests Ramoji Rao for Ramoji Rao, it amounts to contempt of court. Supreme Court order is there. If he doesn't arrest, it amounts to contempt of the House. So he was in that crucial position. And this matter prolonged for a few more years till 1987, when N.T. Ramarao came to power as the chief minister. At the time, Then, and with the intervention of the then Chief Minister N.T. Ramarao ji, this matter was referred to the President of India, and the President of India in turn referred this matter to the Supreme Court for advisory opinion under Article 143 of Indian Constitution. And then this matter was remained pending, postponed, and no resolution was nothing was conferred in this particular issue. Subsequently, in Borababu case, Manipur Speaker, Borababu's case also, conflict between Supreme Court and House took place. The Borababu, who was Speaker, Manipur Assembly, disqualified one member. It was challenged, for which the Supreme Court set aside the order of this Borababu Singh. And in this connection, in this process, conflict between Manipur Assembly and Supreme Court took place. This conflict could not be resolved, but this Barbabu, who was about to go abroad to attend some international conference, but was not allowed due to this issue. In this case also, the conflict between judiciary and legislature could not be cleared, because in India the parliament is not supreme like UK. So this type of conflict took place during British regime in 1780, before 1780, in Kajura case. In Kajura case is very famous. Nandakumar case, Patna case, and Kajura case are famous cases in legal and constitutional history. In that Kajura case, what happened was, in those days there were Supreme Court at Madras, Bombay, and Calcutta, and the Calcutta High Court gave the conflict between Supreme Court and Supreme Council took place. And what happened in this particular case was, Raja Sundar Narayan was the Jamindar He was the government servant, company servant, to collect land revenue. He borrowed money from money lender Kashinath Babu, and Kashinath Babu, a money lender, gave a huge sum of money to the Jamindar of Kajura, and he took loan, but he did not repay. The money lender Kashinath gave several reminders for repayment. The Jamindar did not pay. Then the Kashinath money lender approached the Supreme Court. The Supreme Court issued a writ of KPS to make a presence of the Raja before the Supreme Court. But Raja Sundar Narayan avoided the Supreme Court order. Then Supreme Court became angry and issued most serious writ. If summons are not worked out, then arrest warrant will be issued. Like that, the writ of sequestration is issued against Raja. The Sharif man, the government man, the court person's Sharif man went to Raja's residence to arrest him, but the Raja escaped, and some force was used, and the Sharif man was manhandled also. Then when this Raja was hiding behind, the collection of revenue was very poor, and the Governor General and Council took place to make the Raja's presence out for collection. If Sharif men come, you arrest them and keep them in prison. Accordingly, the Sharif men were arrested and kept in prison. Subsequently, they died in jail. These are the so many conflicts took place. So the Regulating Act did not define properly the powers and jurisdiction of Supreme Court, and similarly the authority of the that is why the Supreme Court was misusing its power in order to resolve the conflict between Supreme Court and Supreme Council, that is Governor General and Council. The British Parliament passed an act known as Act of Settlement of 1781 to resolve the conflict between Supreme Court and Supreme Council, that is legislature, was resolved in British regime in 1781 by passing the Act of Settlement. But so far, this is such a conflict between judiciary and legislature takes place, we are helpless. We are not able to resolve this issue, because the doctrine of separation of power envisages the executive, legislature, and judiciary are three organs of the government to act independently in certain cases, to act interdependently in certain cases, because there must be some checks and balances. The doctrine of separation of powers are not only independently independent but also interdependently independent. So the functioning of one authority is to be examined by the other authority as and when required. This is the reason why the position remain unsettled. Even Supreme Court, when matter is referred under advisory opinion, this thing. So article, the similar provision is there under article 121, 122, 211, 212, that in certain cases courts the conduct of judges of High Court, Supreme Court should not be discussed in parliament or state legislature in normal position except on impeachment move in the parliament. And similarly, in certain cases, the houses are also conferred some independent autonomy to discuss anything to regulate the internal proceedings. Then such the courts also should not, because the Supreme Court in PV Narasimha's case, Narasimha's case said that the scope of the protection under privilege, the protection of privileges and immunities to members of the parliament is very wide. Even courts also cannot dilute the protection provided to them under the constitution, is what the Supreme Court by 3 is to 2 majority, that is 5-member bench said. So this is the position with reference to the parliamentary privileges, dear friend. This is as a member of law, as an advocate or law student, you are expected to know. You know, dear friend, see, even chief minister conduct, prime minister conduct may be discussed in parliamentary houses, parliament or this thing, but a judges conduct should not be criticized, discussed, and they are should not be discussed. Means except on impeachment move in Lok Sabha or Rajya Sabha, means what a great position conferred on High Court judges and Supreme Court judges. You are going to be the lawyer tomorrow, the High Court judge or Supreme Court judge day after tomorrow. So what is the responsibility? What is the initiative you have to take? What are the efforts you have to take to maintain the decency, dignity of our legal profession, and take your legal course very serious and show interest. You have to respect your course. Thank you very much for your patient hearing. Thanks a lot.